Good evening, everyone. I welcome you all to the launch of the book Technology and Analytics for Law and Justice. I welcome you all on behalf of Daksh, as well as the Daksh Center of Excellence for Law and Technology at IIT Delhi. We are very glad to have all of you with us today, and we are also very glad to have in our midst Justice Suraj Govindaraj. Thank you, sir, for being a part of this book launch. I would like to take this opportunity to say a few words about the Daksh Center of Excellence for Law and Technology at IIT Delhi, otherwise known as the COE. The COE conducts interdisciplinary research on various aspects of the justice system and builds solutions drawing from fields such as operations research, data analytics, technology, and law to improve the effectiveness of the justice system. The COE seeks to be a hub for innovative research and implementation models for the justice system. To say a few words about this book engages with the evolution of technology adoption in India's law and justice system, and it aims to chart out the needs of the stakeholders, including citizens. While doing so, this book provides an overview of what innovators are doing and what innovators can do to enable the justice ecosystem to benefit from technology. My colleague Leah Varghese is going to give a deeper perspective on all the themes that are covered in this book. So I would now invite Leah to come and take over the presentation.
Thanks, Sandhya. I'm sure all of you are waiting for the panel discussion, but I'll just do a quick overview of the book so you get a sense of the themes that have been covered and the topics covered. So this is a brief overview of what we have tried to cover in the book. It covers current thinking and practices in analytics and technology for the law and justice system. So this is, we believe, a first of its kind book on this kind of a topic. We've tried to identify issues around technology in legal settings. We have tried to look at how analytics can contribute to justice and governance. And finally, we've tried to take a paradigmatic view of the domains and try to illustrate our views through case studies. This is a brief overview of the range of authors who have contributed to this book. So the way the book is structured, it begins with a chapter that lays down the landscape of technology and analytics for law and justice. Then we go into four major themes: access, assistance, analytics, and an institutional focus. And we end with a concluding chapter which summarizes the book and charts the way forward. So the first chapter is the landscape chapter. So this sets the stage for the rest of the book. It lays out the landscape of technology and analytics for the law and justice sector till now. So unlike the other branches of the government, especially the executive, the judiciary has been a little slower to adapt to technology. We have also looked at the law tech ecosystem, which again, compared to the rest of the startup ecosystem, may not seem as dynamic, but has a lot of potential and is growing really steadily. So we have, we've done an overview of all this in this chapter. We've also traced it across time from the early 2000s, the pandemic, and the pandemic was really a catalyst to adopting technology in the sector and the current state. On access, we have looked at two big questions. One is the digital divide and access to justice. So at Daksh, we do a lot of work on technology, but we are always very aware that there are people on the other side of the digital divide who are not able to access technology. And all technology, whenever we think of technological transformations, we need to design for those people. So chapter 2 covers that. Chapter 3 is very interesting. It goes beyond the formal justice system, judges, lawyers, etc., and looks at what the authors call justice makers, who are other people in the sector who are enabling access to justice. These are people who help communities access justice, help them access welfare, etc. So this chapter gives you an overview of the justice makers and who are often left out of traditional academic and research pieces. Then we look at the technology aspect. So again, a range of topics here. The first one is on legislatures. So of course, a lot of the focus of the book is on courts and the legal system, but we've also looked at legislatures. And we often don't think of, how is technology used by our parliaments and our legislatures. So this chapter gives you an overview of that, not just of how technology is used for parliamentary sittings, but also by committees, by state legislatures, etc. Land administration is the next topic. I'm sure all of you are familiar with the really complex legal issues involved in land administration. It's not just a justice system problem, it is also a problem within the executive. So this very interesting chapter looks at how technology can be used to make land administration more effective and more efficient. Taxation. Again, I think this is something that most of us have a passing acquaintance with because we file income taxes and that's done online. So this chapter takes a deep dive into that, looking at how technology has been used for tax administration. The next one is smart contracts. This is again a very forward-looking chapter that we have. All of us are familiar with regular conventional contracts, but this looks at smart contracts which are executable. The system itself executes them. This is a very futuristic idea, and it looks at how smart contracts will work in India, what kind of a legal framework do we need to have, what kind of technology, what kind of privacy guardrails do we need to have to implement smart contracts. The next two chapters look at forensics and how forensics have contributed to the criminal justice system mostly. So we look at different kinds of forensic technologies and how they can be used by law enforcement agencies to investigate better. Again, the ninth chapter is similar, again, technologies to determine guilt and innocence. The 10th chapter, which looks at technology and national security. So this is again looking at how the armed forces use technology. The chapter looks at each force separately. It looks at the Army, Navy, and Air Force and how they are using technology to become more effective, to become more efficient. The next theme is around analytics, which is data. The first chapter under this theme is on MCA 21. Which is, how is the Ministry of Corporate Affairs using analytics, using data. Then we look at GovTech solutions. So here we describe GovTech as, the bouquet of technology platforms for the government. So we are looking, here we do an overview of what the state of GovTech in India is and what the future looks like, whether we need any regulation, etc. Law enforcement and the use of AI. I think this is, again, a topic that's familiar to all of us, especially people who watch detective shows on TV. So how is AI and technology changing the way law enforcement works? And again, here, we've looked at the various kinds of technology used and the possible consequences of such use of technology. Artificial intelligence in legal data mining. Again, at Daksh, this is a topic that's of great interest to us. How can we use artificial intelligence to mine legal data and get really actionable insights? This is a very interesting chapter for anyone interested in judicial data and the analysis of judicial data. Predictive analysis for justice delivery. I'm sure all of you have heard of predictive analysis, but this chapter looks at how that can be used for justice delivery. And similar to the law enforcement chapter here, we also highlight the possible misuses or cons of this, how we need to be careful when we use predictive analysis for justice delivery. Operations research for the judicial system. So as Sandhya had mentioned, the COE does a lot of work on operations research. So this looks at how operations research can be used for better resource allocation and optimization within the judiciary. Optimal resource planning, this is again connected to chapter 16. Statistical hacks for data analysis. So this chapter looks at how law students need to be taught about statistics, maybe in a non-quantitative, non-scary way, but it makes the argument that the time has come where, the law students' fear of maths needs to be driven away. And it is very important that law students at least understand the basics of statistics. We end with the theme on institutions. So chapter 19 looks at sovereignty and financing of technology in justice. So, I mean, it's very well to talk about the need for technology and what kind of technology we need in justice, but who is going to finance that? Of course, the state finances it, but there are philanthropies, there are private firms that also finance. So what are the things that we need to keep in mind if we are looking at private financing of technology in justice? Startups as disruptors of legal tech. This again gives you an overview of the startup ecosystem in legal tech. This again is a very understudied area because we hear of startups in various other domains, but we hardly hear about startups in legal tech, and there are lots who are doing very exciting work. Chapter 21 looks at estimating capacity requirements of the NCLT, the National Company Law Tribunal. So this is looking at how do we come up with a scientific method to estimate how many members are required, how many staff are required in the NCLT. Chapter 22 looks at the future. So, I mean, most of the previous chapters were analyzing the past and the current state of play, but we end with what does the future look like? And, what kind of reforms do we need to reduce the burden on courts? And, as Daksh, one of our key focus areas is reducing pendency. So how does all this fit in within the larger picture, and how does it contribute to reducing pendency?
I take great pleasure in introducing our panelists for today. So we welcome our first panelist, Justice Suraj Govindaraj. He's a judge at the High Court of Karnataka. He's practiced in the fields of civil, commercial litigation, contracts, property law, arbitration, company law, constitutional matters, environmental law, among others. He's also an alumnus of National Law School of India University, Bangalore. We also have with us Dr. Sarayu Natarajan. She's the founder of Aapti Institute, a strategic research institute on technology and society. It's based in Bangalore. She has a background in management consulting, venture investing, program development and management, and academic research. She has a PhD in political science from King's College, London, and an arts and law degree from the National Law School of India University, Bangalore. Finally, we have with us Professor Nomesh Bolia. He is a professor in the Department of Mechanical Engineering at IIT Delhi. He holds a B.Tech degree from IIT Bombay and a PhD in Operations Research from the University of North Carolina. He's also previously worked at Infotech Financials Private Limited and the Tata Institute of Fundamental Research, Mumbai. His research interests include applications of operations research in public systems such as public transport, justice system, and public policy. We welcome all our panelists wholeheartedly, and we hope for a very engaging panel discussion. This panel discussion will be moderated by my colleague Surya Prakash, who's the program director at Daksh. So, I welcome you all to the stage.
Thank you, Sandhya. Thank you, Leah, for the introduction to the book. Professor Nomesh Bolia, who is the co-editor of this volume and leads the work at the center, will be joining us in just a few minutes. I don't need to tell you the reasons, world famous. But just to set the context for this discussion, and thank you so much, Justice Suraj Govindaraj and Dr. Sarayu Natarajan for joining this discussion. Yes, this is the first of its kind book. Much work has happened. A book is an opportunity to take a longer term view of things. There are immediate steps to be taken, pressing needs, but I think it gives us an opportunity to take a few steps back and say, how are these pieces moving? In which direction are they moving? And see and set the context for all the next steps that need to happen. So possibly the book may already be talking of a situation or painting the landscape which has already shifted, which is why we are calling it Insights into a Dynamic Landscape. As we speak, it has already shifted. But it is necessary to understand the shift. It is necessary to understand which are the parts that have shifted in which direction, and which is what the book does. Not that it does not talk about the actionables, but it does give that opportunity for us. Can I just request both of you to share some brief reopening remarks, then we'll go into the details on your things.
Just leaving it open as opening remarks is such a wide statement to leave it at. And to leave that to a lawyer or to a judge is extremely dangerous. Firstly, I'll have to commend all the authors who have put together all their intellectual labor, physical labor into getting this book out, the writing about it. I can well imagine how difficult it could have been, because this is something which is being attempted for the first time, and these are subjects which not much research is available, especially in India. Maybe in the Western world, in Western countries, there are a lot of articles, there are a lot of research material, but in India, it is a first-time effort which has happened. So firstly, congratulations and commendations to all the authors. The aspect of today in 2023, we are speaking of legal tech, we are speaking of what is the technology that could be used in terms of justice both in terms of courts, outside courts, inside courts. This has arisen only probably because of COVID, so we can probably thank COVID for that in terms of giving these services. We are speaking of services today. What are the services which could be made available, which could make justice faster, more efficient? Earlier, we are not speaking of this. Earlier, it was only a case information system which was only collating all the judgments and the orders and made it available for the litigant or the lawyer or any researcher who wanted to look into it. But today, we are speaking of services in terms of e-filing. We are speaking of virtual hearing, hybrid hearing. We are speaking of paperless court. We are speaking of so many things which are there. We are speaking of ODR. The number of things that are coming about as services, which the Phase 3 vision document speaks of microservices, is mind-boggling. What is it that we could give? What is it that could be provided to the litigant, to the lawyer, and the justice system as such in terms of e-seva kendras? The aspects we can just go on speaking of it. Now the issue would be how to operationalize this whole aspect, to operationalize this book. That is where I would want the talk and the thoughts to go through.
Thank you. Your ears perked up when you heard the word services, so.
Thank you very much. First of all, congratulations to you, Dr. Bolia, and the entire team, as well as the authors, for bringing out what is a fantastic volume. I think having been somebody who's been thinking about technology and formerly a lawyer, I suppose, this book is a very significant contribution to the literature. I think it keeps time for what is a very important trajectory and a shift in the way we imagine Indian justice. So I think congratulations, commendations to the authors. Thank you. It was a very interesting read. In terms of opening remarks, it is a fairly open field, but I think I'd like to set a little bit of context in terms of thinking about technology in the context of the justice system. And my standpoint for coming at it is as somebody who thinks about technology in different aspects of human life. In the way that the book does in different segments, technology in the justice system is not all to be painted with the same brush. Each type of deployment of technology, each type of imagination of technology has very significant consequences, both in terms of the risks as well as in terms of the how-tos of how to get it going. Technologies which are oriented towards increasing efficiencies in the system and process such as, for example, digital ways of keeping records, even to some extent e-filing, comes with a fair degree of focus on efficiencies in the process itself. While the challenges might be questions of access, there are not significant risks in terms of deployment of these technologies in an immediate sense. Having said that, given that this is a core function of the state, the judiciary, thinking through who builds these technologies and how are they governed is critical. Then there is, of course, and I think the book has several chapters dedicated towards thinking about technologies which enable decision-making, which go to the heart of what the decision-making process is. And I think here, the thinking through both the how of deployment, in terms of the sequencing, in terms of having adequate evidence in terms of implementation, as well as longer-term questions of governance becomes critical. Then there is a core layer, I suppose, or core, I don't know what to call it, foundational sort of technologies that enable fidelity in data, particularly pertaining to land records, etc. Which again, the trajectory is long, and I think the book notes that and documents it quite extensively. But thinking through how these might intersect with some of what we political scientists call the politics of deployment of technology might be useful. I'll pause here and hope to circle back to some of these questions. Thank you.
Thanks. So yeah, I think you've rightly pointed out how there are other subsystems of the law and justice system that actually contribute to the moving up of the courts itself. We have to understand the court systems technology as being part of a larger ecosystem, and the larger ecosystem having moved, it will be very, very out of times, out of tune if the court systems don't move. And I think that's a big point that we wanted to make in this book, that everybody else is moving, and there are data flows possible. Courts just need to enable acceptance of this data, validation, right? So, sir, she made the point about the core functions. I think that is a segue that we can. Adjudication is really about life, liberty, livelihoods, rights. Do you at all in your, do you see some tension in using technology and analytics in deciding, in a function that is deciding these? Okay, like you're not deciding, but in a function that is deciding these life, liberty, livelihood, rights, what goes on in your head when you think of these?
So when you say use of analytics and technology to decide, normally today people would jump at saying that it is AI which will be used for deciding a particular matter. Therefore, the AI will replace a judge or will probably be the substitute for the judicial system, and tomorrow you'll have some robotic AI sitting there and deciding matters. Now, this is something which probably for a country like India is way off. We are not there at all, and it would not come in my mind at all. And for me, it's not the elephant in the room. Technology as such, as when we started practice, there's no technology. It was basically a 386 computer which could be used for as a glorified typewriter and a printer to take out the print and file it. Communication, there was no email way back in the year 1995. If it was a general information to the client, it will go on a 15 paise postcard. If there was something confidential, it will go into a 35 paise inland letter so that it is closed and nobody can see it. And that's how the information would go. And if it's an extremely urgent matter, there would be a phonogram which we used to do. Then subsequently, we had emails coming in, we had faxes coming in, and thereafter the emails coming in, telexes in between, all those things. These are all technological aids. It is tech aid which is there. These are only aiding a particular action to be taken. So when I speak of, or when I think of technology as such, I would want technology to aid in the administration of justice more than in the decision-making process, because decision-making process is something which requires much more thought process. It is not only a mathematical algorithm, but it could involve human elements into it, which, for example, it could be a compassionate appointment matter, it could be land acquisition matter, it could be a motor vehicle accident matter. So many of that require a little bit of a human compassionate element also to be built into the decision-making process. So for that, it may not be a technological aid or technology or analytics replacing a judge as such. It could be only for the administrative purposes. Can you guess how many cases were filed between 1st January 2015 to 31st December 2022? Any guesses? 5 lakhs. Anybody here? Let me tell you, today the pendency is 4.5 crores in the district courts, 4.4 crores and 60 lakhs in the High Court. Around 5 crores is the pendency. So, any other guesses? 5 crores. Okay. For a for a block period of 8 years, you say 5 crores. It's a remarkable improvement. Any other guesses? The number of filing before the district court was 11 crore 77 lakh cases. These were the filings in those 8 years. At an average, every year, the district courts across the country see a filing of around 1.5 to 2 crores per year. Now, can you guess how many of those matters were disposed of by the judiciary in that block period of 8 years? 11 crores 77 lakhs filing, what was the disposal? Any guesses? Not more than 10 lakhs. You have very high esteem of the judiciary. 3 crores. You have considerably better esteem. 9 crore 97 lakh cases were disposed. 9 crore 97 lakhs were disposed by district judiciary, which is functioning probably at less than at 70% occupancy in terms of 25,000 being the sanction post. They are working at 17,000 and odd. So disposal was 9 crore 97 lakhs. Now, out of the remaining 4.5 crores, 1.8 crore cases are now pending for service and appearance. Around another 30 to 40 lakh cases are pending for paying process fee. Another 30 to 40 lakhs are pending for compliances. So it comes to around 2.7 or 2.8 crores are pending for these administrative purposes. One of the major issues that we face in the judiciary, either in the justice system, let us not call it the judiciary, justice system in terms of the judges, lawyers, or the litigant, is service of summons on the defendant. Now, that is where, if we have 2.5 crore cases pending, that will take a longer time for it to be achieved. We need to tackle that issue. Technology could be used to tackle that issue. If we come up with a faster mode of service, and if we are able to convert that 2.5 crores or reduce that 2.5 crores to 25 lakhs, you will have straight away 2.25 crore cases which could be taken up by judges, which the judges are ready to take it up. The lawyers are ready to argue, because today, those 2.5 crore cases, nothing can happen. It's not available. Similarly, like that, we could look at so many other issues which could be bucketed and handled.
So you're saying the procedural aspects of it, the administrative actions, could be supported by technology. The core adjudication, we are still far away from seeing any deployment of what is generally known as AI, although we don't like that term.
To further expand on that, AI is being used by some of the jurisdictions. For example, Brazil has Victor, which is making use of AI for matters of general importance. That is what they call it, what we call the substantive question of law. Argentina has something called Promethea, which uses AI. These are all for those particular issues where there's a lot of training which is to be done. For that particular training, we need to have all the judgments digitized. We need to train the AI. We need to digitize all the records, the evidence which is there on record. And then we need to have walls built in for that AI to only access that. So those particular digitization and training will take some time.
Yeah. So, Sarayu, I just pause to let Professor Nomesh Bolia, who has managed to join while the panel discussion was still going on. Hi. So, Sarayu, you work not just on the courts, but technology in other sectors, and this is where I'm hoping that, there is a talk of core function and adjudicatory function, but there's also procedural functions. But when you're doing something radically different, like how it is done in the payment side, these what we discussed as clean sheet design, these things may then become blurred. How have other sectors that you have seen, and we know revenue, so land administration technology is a big factor that can unlock a lot of value for the dispute resolution. Taxation India has seen a lot of values, progress in tax administration for technology, GSTN, income tax returns, it's for a long time, right? So how are you seeing these various sectors handle development appropriate to them? And what do you think that has to teach people who are working on the technology for the justice sector? Can we leapfrog some steps?
Thank you for that question. It's a difficult one. I think one key thing that we have to remember in talking about technology in the context of justice, whether in the procedural or in the adjudicatory functions, is that both of these are imagined with friction in the process as having a very specific purpose. And it goes to the core, at least to my mind or my limited understanding, it goes to the core of dispensation of justice, both on the procedural side as well, and obviously on the adjudicatory side. So thinking about friction and what kinds of technology can get around or remove or eliminate what kind of friction is, I think, the way we need to think about it. That is not to say that technology has no use, nor that we should be critical of it upfront. What all that means is that we need to think very deeply about what the friction does in a specific instance. There are some delays which are unreasonable or do not make sense and do not add to the the sense of the decision-making process. Others which do, and I think knowing that distinction may be a good starting point. What I think we can learn from other sectors, and this is not just technologies that have been deployed in the context of governance, but also technologies that have been built in the commercial space. I think a few lessons that we can definitely learn with respect to this relate to friction. I think friction both gives pause, it enhances the process. So thinking about, why do you have an OTP process in certain instances? It has both a fraud mitigation capacity as well as one that gives you pause in a commercial transaction. So those kinds of lessons are definitely worth learning. I think the other that might be very useful for thinking about technology in justice might pertain to the ways in which data is imagined and negotiated, navigated in the context of different sectors. There exist both ways in which data is sort of made available to communities of researchers, innovators, etc., as well as efforts built to increase analytical capacity within these communities. So that's another sort of dimension to keep in mind. I think, though, that in all of this, my broader sense is, and we can learn both, how is friction navigated, what was the purpose of it, and then how do you think about deployment around it. But a very, very critical thing that we'll end up missing in the context of deployment of technology with respect to justice is actually capacity. And I know we're going to come around to discussing that hopefully over the rest of the discussion. But thinking about who is going to navigate this transition to a more digitized system, and what are the roles of different actors in this? What roles can they play? Normatively, what roles should they play? I think those are both questions that we need to talk about. And again, I have a skepticism in some senses of exceptionalist arguments, but I do think in the case of the judiciary, it is merited. And all that means is that the mindfulness around each decision with respect to technology needs to be somewhat different and measured. So I'll pause there.
Great. So that the friction is a fantastic, a point that a lot of us need to think about. That there is a purpose to certain, design. But on learning from other sectors, I think there are things to learn from another sovereign function. I think we need to understand that adjudication courts are a sovereign function, and therefore, it's a favorite topic of yours. So I'm sure you'll cover it better. But just the taxation side, the tax administration side is another sovereign function. And the way they have gone about it over the last 20 years has led them to where they are now. So there are things for us to observe how they have done it nationally, how they separated stock from flow, how they separated core taxation from tax administration. So there are learnings from the taxation regime digitization at a national level for the judiciary, something that we all need to think about a bit more. But your point about data, for example, brings me to Professor Nomesh Bolia's, one of the leading operations research academics in India. Not just academic, he's contributed to a lot of projects. So Nomesh, a lot of discussion on technology in the judiciary starts and ends with video conferencing, right? It's very important from an access perspective. But as somebody who's seen many systems, public systems, what do you think, why do you think the discussion needs to move to data analysis, what we've called analytics in the title of our book? And what do you think it can offer to the citizens at large, but more particularly to the system?
Okay, thank you. I should apologize for being late. I can't blame the traffic, can't blame anything. It's all my poor planning. Really sorry. But no, that's...
I already blamed it on the traffic. Now you're making me look bad.
Yeah. No, there was that, but I think we should all, account for all of that anyway. All of us know how bad Bangalore is. I can say that because I'm coming from Delhi, right? It's much better in terms of traffic. Although much worse in terms of most other things, but traffic-wise, we're much better. No, so this is a favorite topic of mine. I think not just technology, but even the way, several state institutions are talking about data itself, to us at least seems very preliminary. It essentially just boils down to somehow collecting data and then just making tables and not even putting them up in Excel format. Just putting them up in PDF format, which really doesn't get anybody anywhere. I think it's an exercise. Don't quote me anywhere, but I think it's just an exercise in vanity. We're just satisfying somebody's ego by saying we are collecting a lot of data. There is any number of applications and use cases in all kinds of systems, public systems, industry, on how analysis of data can be very beneficial, both from the point of view of architecting a system better, as well as letting the users of the system, letting them get more out of it. So specifically in the case of judiciary, for example, we've been trying to work on one project for quite some time. We have not got hold of the data, as well as we would like it to. Although, to our credit, there's an amazing amount of data. I think we are among the best in the world in terms of putting data out there, but it is not yet ready for research. So that itself, is one thing that we should be looking at as to what we've already decided to make public. So it's all out there anyway. There's nothing to hide now. How do we make it more research friendly, more analysis friendly? That's one. Second, if we had that, we would, for example, be able to say things which we are right now saying more out of some analysis, but probably a lot more intuition, is what is the role that various litigant pairs are playing? So what happens, for example, if you do an analysis, if the government were to stop petitioning lesser, what would happen, right? There are all kinds of payers, right? Private institutions, government, both of them in petitioner or respondent, all of that. So, we are trying to do that analysis, again, because the data is not in the right format. I don't have results to quote right now. But we could, for example, also say, okay, this is a particular act, and this is a particular section, and this section seems to be causing a lot more delay than others. So either there is a provision there which is getting misused, or maybe the way the section or the act is structured itself has a problem, things like that. I think that analysis can come forth. In terms of administration itself, and this is something that all of us would have seen in our lives, the way cases come and flow through the judiciary, through various stages, they form what we call queues, right? All of us know how, when you go to a bank, for example, or when you go to a railway station, and let's say there are, large railway station, 80 counters, 100 counters, if you were to give a token, which is what most systems do today, that can theoretically be proven to be much better than everybody forming their own line. There are reasons why that happens, very technical reasons why that happens. It can be predicted. I can also tell you what the improvement will be for a given number of counters. So like that, one can do analysis, queuing sort of analysis on this whole system about what stage is giving us the most bottleneck. Where do we need to put in more thought, more resources, more investment? Not even monetary investment, but just sort of reallocating resources accordingly. So things like that. We can also actually, and there is one chapter in the book that talks about it. We can also analyze this data using OR methods. And for example, say that without adding even a single judge, just transferring them, and that too with all restrictions. One can say only within a district, one can say only within a high court jurisdiction. Just do that little transfer, and there is some impact to be had on the clearance rates just by doing that without adding any resources. Now, this analysis is preliminary. We have not really worked with the judiciary. I know there are many things that we would need to take into account if it were to be implemented. But what it shows at a preliminary level is that there is some advantage that one can at least hope to get if one were to do that more properly. Even more mundane things, this is my last point, and there are many, many things that we can keep sort of discussing. But in our interaction with the district courts in Delhi, the High Court, we realized even something like calendaring, how do we schedule cases properly? That is a problem that not every judge would like to get into, right? I mean, it would be great, I think, if I was in their position, I think it would be great if someone were to tell me, give me a tool and say, well, these are the cases, and without violating any of the constraints that we already have about the seriousness of the case, about, priorities, without violating any of that, or any other rule that we might set up, one can get a lower turnaround time on cases just by using the data right, by making the right kind of models and doing the right kind of optimization. So a whole bunch of things that can be done.
It's interesting when we started discussing with Nomesh and team, a lot of the conversations we had at Daksh and Harish and I have had with many judges, some solutions used to come up and say, this could be done. For example, transferring workload between judges. Many people have said, why does one judge have 10,000, the other has 1,500? They're sitting next to each other. It can just be balanced. These were solutions that came up in these conversations. And then when we started speaking with Nomesh and team, we realized that, this is typical of what other sectors also face, right? So there are methodologies and approaches that are applicable across sectors. And there are needs from judges and people in the justice system. Just that somebody needs to say, you need to apply this method here. And that is what we're hoping to do these conversations on the COE and hoping that there will be so much more of an uptake in adopting and being open to these methodologies. Sometimes some people in the justice system seem to think of this, it's a sovereign function, but at the end it is also a system like any other system, right? So therefore there are unique points, but there are also learnings that can be had from many other systems, right? That brings me, this is Suraj Govindaraj, to the question on, there is one thing to be said about being open to data learnings, open to data methodologies. The other is, being able to deal with data, right? just being numerical about things. So possibly, because both of you are from the legal fraternity, from your judges' first perspective first, what do you think can be done? We do have a great chapter by Professor Ashish Kulkarni and Murali Nilakanthan on data for statistics for lawyers, and also a couple of chapters on forensics, right? On for in the criminal space. So thoughts on how that can be improved, both the willingness of course is a larger, longer term, but at least the capacity to engage with data solutions and analytics.
I'm glad that we are thinking of it on these lines. Let me start from there. When did this thinking process start? Probably very recently. We haven't had this kind of a thought process prior to, I think the change is from COVID time. The change is with the digital public infrastructure which has been brought in, with the success of the UPI, with the success of NPCI, with the success of UADI. Those are successes which have got us thinking of these digital public infrastructure for digital public good. Now, judiciary as a digital public infrastructure and digital public good, how do we do it? Analytics, the data, etc., are there as a foundational aspect of it. Now, the data, as Professor Nomesh did mention, that there's a lot of data, but probably relevant data is not there or is not structured. Now, when did we start thinking of this, that we need this data and how do we need this data? So put it across that this is what data we require for so-and-so purpose. Like in the Western world, you have universities which contribute to the development. The university, the professor act as friend, philosopher, guide, and who say that this is what the future ought to be and this is how we can reach there. And these are the things that we need to do to be there. And this is where the world is going, is how a Western professor would put across. And for the purpose of ranking of a university, 30% of it is for research papers, 20% is for citing those research papers, the students writing about it, and those research being acknowledged by the peers and recommended by the peers. Unfortunately, in the Indian context, we are not having that. We probably need to look at that kind of situation and encourage the educational institutions, the philosophers, the people who are the academicians, like IIT. I just loved the way that you put it across, and I see the passion that you have in it. We need that passion. We need that passion in the law professors and various other institutions to say that this is what data is required to be gathered, and this data is to be gathered in this particular manner. And once it is gathered in this particular manner, we can use it for doing A, B, C, D as a use case analysis. This is the kind of approach that needs to be put across for people to understand that this is a possibility. See, we as judges, we have generally around 15 to 16 hour working day every day. So to sit back and think about it and see what that could be would be a little difficult. It could be better coming from the academicians, it could be better coming from the think tanks as to what could be done. And as a guidance which comes across, what data is required to be structured in what particular way. Today the CIS, which was a humongous effort to put in, at that point of time, there was no play. The litigant or the lawyer did not know what had happened in his matter, what was the daily order which had been passed, what was the judgment which had been passed, how does he access it. To collate 25,000 courts into one location in the National Judicial Data Grid and say that this is what it is. Today, this many filings have happened. Today, this many disposals have happened. This is the orders which have been passed today, and they have been uploaded. Maybe not today, it will be uploaded tomorrow. These are the judgments which have been passed. You can look at it. This is the appeals which have been passed. This is the pendency. To get to that stage itself, hats off to the people who did it. It was a fantastic job which happened. That is the case information system. Today what you're speaking of is services. The services in terms of case management system, dispute management system, judiciary management system, or justice management system, we need to expand from CIS to that. And what are the ingredients of that need to be put forward? Those are things that we are working on with Vision 3. Phase 3 vision document is there, the DPR has come out on that. Those are being worked on, but a lot more needs to be done, and like anybody says, when all is done and there's more to be done then. So that's how it is. And in terms of judiciary is, or legal litigation, even for any company, is always a cost center. It is never a profit center, unless you are in the business of litigation, if you are in the litigation financing. But litigation is always a cost center. So even a litigant doesn't want to spend on the litigation, so also anybody else, even the government. Now the aspect of whether it is a cost center or not, whether it is a situation which impacts the society or not, would also have to be looked into. And that is the reason why there is no private enterprise which is developed in the litigation field. Sandhya was speaking of, and Leah was also speaking of, there's not much of private investment into legal tech. That is because there's no income out of it. A legal tech, if it provides a solution, how many people are going to take it? Citations, the judgments, yes. What are the other services? Could people in the taluka level, the court fee for filing a suit for injunction is 25 rupees. So what is it that that lawyer can afford? Most of the lawyers in taluka level may not even be earning 5,000 rupees a month. How are we going to include that lawyer and that litigant into this? One thing of the urban litigation or the corporate litigation is one thing, but the majority of litigation is arising there. The corporate litigation, IP litigation, which are the firm-oriented litigation, are minuscule. Minuscule. Maybe not even 1%. 99% is there. So those people need to be included. Those are the places where services have to be given. Like the Honorable Chief Justice of India, Justice Chandrachud, has come up with a repository of judgments. Now we have a repository of all judgments of the High Court and the Supreme Court, which are available free of cost to anybody. Those are the services that we need to look at. We need to look at the legislations being available. The judgments are now proposed to be made available in the local language. The judgments of Karnataka High Court will be available in Kannada for a person from Karnataka to read it. We may be happy with English, but the person will not be able to understand an English judgment. These are kind of the services that we need to look at as to what could be available free. One is monetization. This is the, because monetizing services in the legal scenario in a country like India where the litigation costs are not that great. We are not in the US where litigation is a business. We are in India where litigation you are driven to as a last resort. You don't want to go to court. You don't want to go to a hospital. You don't want to go to a police station unless you are forced to do it. So you go to a lawyer only to buy a property, otherwise no.
Actually, that actually raises a very important question on how should legal tech be funded, which is what the Aapti team has actually written about, how there needs to be a broadening of the imagination of structures for funding of legal tech. But you want to just add to that or respond to the previous question? Go ahead.
A little bit of adding to that, and there's a very interesting chapter that my colleagues have written on this, and thinking about, and I think Justice, you mentioned it, the thinking about both financial and non-financial ways in which some of these systems could be funded is critical. Some of it might come through direct money instruments. from different sources. So thinking through what it might mean for different entities, whether it is the state, philanthropy, sometimes even business, because there might be perverse incentives from having businesses play a certain role with certain aspects of the judiciary, as well as non-financial incentives. What are the ways in which capacity is provided by different kinds of institutions, whether think tanks, universities, etc. So that's, I think that's a whole discussion in and of itself. But just a quick response to Sir's point and Dr. Bolia's point around data specifically. Many years ago, I did some work on understanding the Prevention of Atrocities and the Protection of Civil Rights Act, POA and PCR. And we tried, and this was in 2011, so I'm dating myself here, but we essentially tried to understand both stock and flow. So where are cases, how frequently are cases being filed, as well as how are cases going through the system. So what are the various steps in the process, etc. And we tried to map it out. And there's a paper there somewhere in the ether, in PDF, I assure you. But there's a paper there somewhere in the ether. But one of the struggles was, I think, exactly what you said, which is that what aspects of it are deterministic and can flow through a system where you can identify and then apply analytical capacity to it, and what elements are human. Essentially human, and POA, PCR is very core to how we imagine ourselves as a society. So what elements of that are human discretion? I think mapping that and working quite closely with technology. So that comes around to the point around capacity, but working closely with those who understand analytics is very critical. Because as lawyers, we tend to think all of it is discretion, and all of it is friction, but what are parts of it which are deterministic, going through a system in a 0-1 fashion, and what are elements of it, or where you can at least infer certain categories, and what are points where you cannot, I think is one thing where communities of people who understand data and technology and lawyers need to come very closely together. But that takes me to the point around capacity building. My own view on that is there are two parts to it. One is how do you embed thinking about data analytics and technology in systems, which is a question about how we engage with universities, how universities engage with data, how curriculums engage with learning about technology as well as statistics. I think there's a need for a deep conversation on how we do these things. There are some core values that you need to learn as a lawyer, and there are some core skills which have increased in terms of what you need to learn. And I think one is working closely with the university system. But I think there's a vast number of us who don't really understand. The 2 courses on statistics I did in grad school were illuminating. But having said that, I think mutual adult education is really where we should start. I was in a recent discussion on AI, and just as much as lawyers, public policy wonks, I think that's what they're called nowadays, do not understand technology, there's a mutual sort of lack of recognition of why are certain things rights and why are certain things not. So having that mutual conversation and having platforms and fora where such conversations can happen is a critical part of capacity building. I think there's another tinier element, and maybe worth mentioning, is that as we go forward with the deployment of technology in very many domains, Meta as an algorithm, social media communication, they're all like work is entirely algorithmically mediated in certain sectors. So thinking through what capacities to decide about these systems might mean is also very important. Because as these are litigated in various ways in our polity and in the courts, having ways to think about how do we think about justice in those contexts is critical. And very many of these are in domains where there isn't necessarily a statutory framework, so some caution there.
Correct. I mean, the statutory frameworks need to develop over time, and rightfully so. You can't over-regulate or pre-regulate or, Any thoughts to add to that, Nomesh, on capacity building for data? How have other government departments or agencies responded to data solutions?
Yeah. So, before talking about that, let me just, come back to your previous question, just to end that. I remembered something very nice. What we are all sitting on right now in terms of the judiciary, I think you've been amazingly visionary in just putting all the data out. I can't even begin to tell you how good that is. No other organ of the state has done that. Absolutely no other. And from what we know, at least so far, no other state in the world has also done to the extent that we have done. And this we did regardless of COVID, regardless of everything else actually, I mean, so many years back. So which is just absolute hats off. But at the end of the day, what that leaves us with is a computer which doesn't have a software. We have all the machine that's lying out there, but we can't make any use of it effectively. I think that is, one strong reason why we should move beyond that and start working, like she said, with so many other stakeholders that arise here. This capacity building, I think there are many ways where other people have done it. Stakeholder engagement, like she talked about, different people talking to each other, short courses in universities, full-on programs, talking to each other for curricula, things like that. I think there are many, these days we also have a podcast, right, for example. So there's many things that can be used, technologies right there to help us through all of this. I think what is missing right now, and pardon me if I'm wrong, right, is a strong willingness at a critical level, at the tipping point, where the key stakeholders in our law and justice system feel that, okay, now we need to do something about it. I think that their intent, I think, is missing right now. Once we cross over that, I think there are many people who are technologies, people, methodologies that are waiting right there to go forward. That would be my take.
Yeah, it may also be a generational thing. Maybe once the next kind of people who are more familiar, the digital natives come up, maybe it will become more, right? So, but that you make an important point about institutionalizing these initiatives, right? And that's something that at Daksh we have faced and tried to work on. There are initiatives taken by few people and that are always subject to the vagaries of all the administrative setups that we see. How can these initiatives that have been started be institutionalized so that they can be carried forward beyond tenures, beyond interests of certain group of people? How can the entire court system be saying, we are working towards making this happen? What are the steps do you think that need to be taken to institutionalize these initiatives?
In terms of E-initiatives, we have the E-committee headed by the chairman of the E-committee. At present, the Chief Justice of India is heading it. So any action, any initiative comes through the E-committee, flows down to the compute committees in each of the high courts. So as regard the intent that Professor Nomesh was speaking of, the intent is there. In all the courts, among I think almost all the judges, because there would also be a personal interest in terms of if I'm having 10,000 cases before me and if that gets reduced to 5,000, I am better off. So that intent in terms of the personal interest and the societal interest is also there. But the aspect is what is to be done. In this 2 years, we have been speaking from just as no VC to AI. This is the paradigm shift or the jump that we are making between multiverses in this last 2 years. To expect anything to happen on everything in this 2 years is a little difficult for that to happen. What I would say is we'll have to look at each and every item that, as I was telling you before, was how do we operationalize the thoughts that have come across in this book. There are a lot of thoughts which have been put in, there are a lot of things which have been put across to say that this is what is to be done. But that is not as an operational methodology, but that has been put across as a philosophical or a thought methodology. Can we operationalize it, saying, for example, data, as you said, data, these are the data which are required in this particular manner, and this is what we can do. This is the operational research which has to happen, this is how it has to happen. This is the services which are to be required. These services can be through, for example, e-Seva Kendras that have been set up by the E-committee, where anybody can go and use the e-Seva free of cost to e-file, avail the e-services. Could private enterprise step in and say that we are going to provide these e-Seva Kendras free of cost as part of our CSR? Could a private enterprise come up and say that we'll set up these institutions to educate the lawyers on e-services, to educate the litigants on e-services as part of their CSR? Could we have the universities, the law colleges, teaching these e-services to the students who are enrolled into law, so that they are aware of what it is, probably from the 4th year, probably in the 5th year. So when they pass out, they know exactly what it is, and even if they have a senior lawyer who doesn't know anything about it, they can aid and assist. So that itself could be a paradigm shift. That itself could help so much. The people are not aware of what like our mobile phone. We use our mobile phone because it is so easy to use. We need to make our software and our system as easy to use. When in the early 90s, banking was made computerization, there was no internet at that time, computerization of banking. There was so much of labulla about it that this will happen, so many jobs will be destroyed, so many, when your money will flow away, there could be, you don't know what is going to happen, etc. But today, when did any of you go to the bank last? I haven't been to a bank for ages now. You want a loan also, they'll come to your place. Any transfer, you can sit at home and do it. That is the ubiquitousness of how the banking sector is working today. Can that be made to other institutions? That is the way that we need to look at what is the benefit that comes about from use of this to be made known. And that benefit should be immediately understandable and measurable, if we can, to that particular lawyer and the litigant. If that happens, all these can easily be achieved. And the intent of using it in terms of technology, yes, everybody is happy. We are not using computers earlier. We are not using printers. We did not have inkjet or laserjet printers. Today we have all those things where it's printed, it's uploaded. We are using digital signatures for uploading the judgments. So everything is, we have QR code, now we have postal integration, we'll know when it has been served. Can we use a wallet, for example, that there's a wallet tied to a particular lawyer and any payment is automatically deducted from that wallet? It's a service. Can we use that? Can we come up with these kind of use case scenarios, which are practical and which will make a difference to the life of that lawyer and the litigant? Those use case scenarios is what will aid the use of technology, because without that use case, the best of this one you will not use.
Practical application. Sarayu, if I could, just pursue that question with you. Other arms, I mean, the executive, the other institutions, they've come up with Center for Smart Governance, Center for E-Governance, they set up analytics cells, tax departments have set up their own tax research and, analytics cells. So do you think there is space for that in the judiciary also? Or, how do you think, what ideas do you think have on that?
I think there's a lot to learn from the deployment of technology in several of these domains, as well as from global examples of how technology horizons have been executed. I think if one were to sort of summarize the takeaway in one line, and I think the paper that my colleagues have written does allude to it, is that the non-financial contributions of several actors has been very significant in the deployment of technology arcs in very many instances. And that means the role of universities, the role of think tanks, and in some instances, and this has to be governed carefully, the role of corporations. So of course there is space. There needs to be institutions that work, and one must, to step back on this specific question, one must think of impact or value as networked, so it is not necessarily held in the hands of one particular institution. So needless to say, there is a room for a variety of institutions. Some that strike me as exceedingly important quite soon is something like the Center of Excellence, which is thinking about some of these questions, writing about it, and articulating both, what exists, what those challenges might be, as well as taking a forward-looking view and a horizon of, what kind of technologies can and should be deployed. I think there's also a space for an institution, and this could be a university or somebody, that looks at deployment journeys across different sectors and takes what has worked, what has been relevant, and pulls it into the judiciary itself. I think there's also a case for the state to have some of its own research, and the Department of Justice has been making great leaps in terms of thinking about some of this from a research point of view. And again, this is not an exhaustive list, but the broad takeaway is that non-financial, sometimes finance for various sources, but the building of a network of institutions that are all thinking about the problem from different dimensions. And of course, there'll be friction, there'll be politics, people will hate each other. But having that networked view is very, very significant in the long arc of technology deployment.
Yeah. So I think Justice Suraj Govindaraj, whenever we speak with him,
if I can, sorry
Yeah, sure.
to cut you. Just one, since you asked about institutionalization, and I, being in Delhi, I think I care about it a lot. I think there are two elements, and that's where I think the executive arm of the state versus the legislative and the judicial has sort of gone forward. One part is, there is a sort of top-down way of figuring out how to do institutionalization, which really means setting up a committee for vision, strategy, things like that, right? Which also the government has done, right? So, for example, something as critical as national security strategy now has a professor from IIT Madras as one of its members, right? Something as critical as that also, I think they've managed to put people, and not just professors, I mean, they also have people from other walks of life. So that is one way. But that maybe depends on from person to person, and that maybe comes after you get confidence, all kinds of stakeholders get confidence in each other's ability and the trustworthiness and all of that. What really seems to be working well in Delhi, at least, I don't know about state capitals, is there is an organic sort of institutionalization. Very interesting. So any government department.
You mean Delhi as a state or?
No. Delhi as the union capital. And we usually, what I'm going to say, we usually get it from the union government, not from the state at all, actually. So what happens is, when you govern, and it's only expected that the executive will do that. They have the purse, they also have the, problems and all of that, right? So, but any problem, they have figured out a mechanism to reach out to educational institutions like us and either issue calls or just send an email, seek a meeting with a professor, with the director, whoever. And all of it happens actually at the same time. Things get done very quickly, So somebody will come to me within, a week. We would submit a proposal. 2-3 weeks they will take to approve. 6 months we complete the study. 6 months they take, and 1 year it's all done, implemented, right? So not just that, they also have now figured that there are non-financial rules like you were talking about. So almost every month, I think I will get a call from some department requesting to be on some committee to advise. And all of it is, non-financial, right? So we can't really charge to sit on committees that way. So they have figured out this thing. I think somebody would have started. I'm sure there would be initially some hiccups, right? Some misgivings also maybe. There would be some lack of trust. But over time, both sides have figured out that it makes sense to work together very, very organically, I think what also happens interesting, for example, I was invited, maybe about 8-ish years back when I was still fairly young in the system, I was invited to be on the jury of the National E-Governance Awards, right? So first is they could think of inviting somebody young like me to do that, right? And then when you go there, you talk about various things, right? You don't just be a part of the jury and come back. So that itself led to one more project actually, that meeting with them, and we told them what we can do, exactly like what you described. So we gave them a use case, we told them, there was a certain model method that we developed. We said, we don't want any money. We have the money from some other sources. Although we don't say that often, right? It's rarely that we have the money from other sources. So we told them, and they just, just had to say, yes, we agree. And they just had to give us that access. And we visited several places in the country and did whatever we had to do. So this organic kind of institutionalization, so now it is almost an institution. So they know they can approach any of the IIT, specifically IIT Delhi, because we are almost next door to them. That I think has worked reasonably well for that arm.
You'll be happy to know that organic institutionalization has already started happening in the judiciary. We will see more of it in the days to come. But I just wanted to, the last possibly comments or conclusions, or what do you think we should look at next? You've told me, whenever we speak, Justice Govindaraj always says, how do we make this happen? Right, so that is very clear from your side, sir. But as a last concluding comments from all of the panel before we open up for audience questions from your side, all of you. The question is not a question; it's really what next and concluding remarks.
What next is everything. So, there's so many things to be done, miles to go. We have spoken of so many things that are required to be done. Question is now who and how. Who also we have spoken of to some extent of being the educational institutions, think tanks, the NGOs, the people who want to do something, want to make a lasting impact on that. How? Use case analysis, use case situations. Pick your topic. There's so many things. Pick your topic into that particular aspect and say, for example, how should a cause list be? Now, cause list, we were having a discussion about it the other day, as these are the things which are required to be there. Okay, now you're telling me that there are 30 items which are required to be there. But these 30 items, how are we going to present it? There's a UI, UX, user interface and user experience for the cause list. It should be comfortable for the lawyer, it should be comfortable for the judge, it should be comfortable for the litigant. And it should be intuitive. So if you're saying so many things are there, make a draft of that, make a prototype of it. As simple as a cause list in a court. Can we have a prototype built? Website, you're saying so many things are required to be given on the website. Okay, what are they? And how are they going to be integrated? And how are they going to interact with each other? Like when we had our website earlier, Surya would probably know, or Arish would probably say, that we had the data scattered around all the places. Now we have got case status, everything in one place. Similarly, can we have a use case or a prototype of the best cause list? Maybe a clean slate, maybe a blue sky, maybe whatever. Can we have that? E-filing. In e-filing, can somebody work on it and say that this is how the e-filing has to be, and this is how it will become easier, and this is the software which has to be developed for it. Paperless court, this is how it could be. Each and every item which is there. Service of summons. Payment of process fee, payment of court fee, payment of all the fees, all the payments to the courts. Each of these are different components. So any person, any organization, multiple organizations could work individually or collectively or in competition with each other and come up with their own thoughts as to what could be and present it. It could be a point of talk. It could be a point of one day you could have a seminar from morning to afternoon or evening only on the cause list and the benefits or the pluses or the minuses of different cause lists generated by 5 different organizations. And then finally you say, okay, this is what it is. And you have a standard that you come up with saying that this is a standard cause list. This is a standard payment methodology. This is a standard so-and-so. This could be worked upon as a constructive, solution-oriented approach as to this is the best way that this could be done. And of course, this is not sacred, it is not written in stone. In another 3 months, it may change. because something new has come. So as on that date, fine. But we'll be open for making a changes as and when, but change is slow. It may be 6 months or 1 year down the line. That is the way I would say you need to look forward and work on it as a, not as a historical analysis of what has happened, but what ought to happen, and this is the way that we could do
Thinking
this.
through deployments, what it will mean. and
Exactly.
Sarayu, any?
Very few brief, only additive thoughts. I absolutely agree for the need to have almost like reference instances. And I keep thinking of the UPI example until the Beam reference application was built, and that's speaking specifically of applications. It fostered that sort of wave of developers after that. And that's a very limited example and a narrow one. But having said that, there's something there. I think my only additive is that there is a we're making two transitions at the same time. We're making the transition to use technology and having to have the attendant governance transitions that accompany that. So while we do all of this work on building out sort of reference examples, I think the only addition I would make to that is to say we need to build out ways in which governance will have to change, capacities will have to change, etc. The other, and I'm going to manifest a wish for the ecosystem, I do believe that there's a need for an organization or an entity that holds the community together, which means that, asking some of the tricky questions while also pushing forward, technology. And I think that that's a role that this space can, benefit quite significantly from. Thank you.
Anything, Nomesh?
Yeah, so I mean, let me just end by saying that maybe about 3 decades back, NIIT's raison d'etre, right, the reason of existence would be to teach. We've completely changed that now. Nobody among us now thinks of, everything got done just by teaching. Everybody wants to do research. The last 10 odd years, there's another interesting transition where maybe 20 years back, people would be happy in doing research in terms of only publishing papers. They would be okay with that. Most young people I talk to among my colleagues, they're not happy with that at all. They really want to do research that matters, that creates an impact. What I think they lack is, so if you look at it from the side of an academic, a paper gets them certain recognitions, right? Apart from satisfying the intellectual curiosity, helps them take their career forward. If they have to do something impact-oriented, they will need the right kind of access, and they will need to say, okay, we are going here, this makes sense, this probably stands a good chance of being implemented if I were to do, if I were to work hard enough. Unless that signaling is not there, it'll be difficult to get these people on board and commit themselves to give time, right? So if we can create a system where there's that clear signal, right, that, we need this, you work on it. If it goes through all our filters, then, we can sort of assure that, it might see the light of the day in terms of implementation. Implementation and impact is a key driving factor. I think we should all try to leverage that.
Agree completely. Kerala High Court has tied up with the Digital University, and Digital University professors have been working on ramping up or revitalizing the entire system of Kerala High Court IT. So there's already a use case scenario where it has happened. And what you said is basically a chicken or egg. So there is some risk that this generation probably have to take. To say, okay, let me do this and then see where it takes me. Because at some point of time in IIT, somebody took that call. And that is what led to further professors following through. And that is how in other universities, other places it would have taken. There's one generation which has to take that call and say that we will, as law professors, say what it is. Today, they could probably say, what is the civil rules of practice? What is the ideal civil rules of practice? Can we amend, can we draft a civil rules of practice? Can we draft a high court rules of practice? Can we say that these are the amendments that could be suggested to a particular law? Whether it's accepted or not is a different thing. It's a thought process in terms of coming up with something with a rational basis and reasoning as to why they've come up with. That becomes a talking point. That becomes something for people to deliberate upon. And if it is valid, it could be accepted by a legislature. Ultimately, it's the legislature which will decide. But it is a thought process. Like Vishaka guidelines came because of that. RTI came because of that. These are things which have happened in the past. But can we look at today's civil rules of practice which can enable technology in judicial process? So we should enable all the rules which are applicable. The rules which are applicable should be enabling. So somebody needs to work on it. It is not just the judiciary or the executive or the legislature. It could be people in the domain.
Thank you. I think with that, we'll see if anybody has any questions. Anybody who has questions, if you could please come up to the mic here. That's the BIC. Please, yes. Huh? No, there's a mic there because the video will also be recording their questioning, the questions. So they usually have to walk up to the mic. We also
Thank you all for giving me the opportunity to present this question. I had only 3 copies, I'm sorry. See, my high-level question is, we have RTI, which basically says if government has a copy of a paper record, people can request it. Now the question is, in this digital world, are we open to going to RTI 2.0, which basically says, is government going to record and make processable the data sets that would be in public interest? Okay. So when we are talking about these transformations in the 10 areas, the thing I would really want to see is, are we recording the right data sets that will control corruption and inefficiencies? I mean, in executive, that's a bigger problem, especially in, if you look at land records. Today, possibly there is a amount somebody is willing to pay for registration of their property. Do we have the data sets to contain that simple transaction? That's something I look at when I review your book. So in terms of judiciary, I guess the thing I'm saying is, there is a workflow. That's what the professor was saying. We file a document, and then there is a hearing. Then judge maybe says, here is your next hearing. Then there is a cause list that comes out. What's worrying for me is the cause list comes out at 8 p.m. the day before. I'm fine with most of the cases, but I worry who has the control to alter that cause list when there are very serious cases, especially in a backlog when even hearing a case has, is important. It's power, right? So my question is, even for the cause list, if I look at it, the computer technology is there. When a judge posts a hearing or when a computer posts a hearing, what caused that listing to be made? Did somebody have control to remove that listing? Or did somebody have the authority to add that listing? That should be auditable data. So this whole thing I define as workflow. So the question is, are we willing to go ahead and make this workflow data, record that workflow data, and make it processable? Then can the judiciary defend its processes? What I mean by that is, I look at the number of hearings that happen, the number of adjournments that happen, correct? So, if I make this data processable, I'll be able to say against what law, against what department, against which judge, against which ASG these adjournments are happening. Why can't we record this data and make it processable?
So those are 3 questions, sir, so I will have to just pause you there. I think the one on RTI, I don't know whether any of us have the, the domain expertise, but on cause list, something, if I may take that up, sir. So that's exactly the question that we have raised in the Daksh's listing project that was launched, last year, early last year. The question on how cause lists come up, and actually Justice Suraj Govindaraj was the guest of the keynote address that he gave in one of the law colleges we launched this listing project. Very valid questions, and we hope to engage with it. It's not simple. It's something that needs to be engaged with at each court level, we have raised that question from the beginning, and we've hope to have others join us in that journey. So please do reach out to us with your thoughts and comments, and we'll take it forward in a more constructive.
Absolutely, yeah. But that workflow data definition,
Absolutely.
that's comprehensiveness is crucial, because unless judiciary records this data, the other departments are unlikely to open up the data.
Yeah.
Thank you.
Thanks. I could request, given the paucity of time, if I could request to keep the specific questions.
My name is Sri Kumar.
Yes, sir.
Thank you very much for a lovely discussion. My 2 cents, you asked the question, what next? So I will give you 2 use cases. One, I think Justice Govindaraj will be able to solve. Second, I think the professor from IIT Delhi will be able to solve. I have gone to the SCR database and used the word Telgi, because I am writing a book on Telgi and how we handle. So it gave me a list of 209 cases. I asked the question, how many Telgis are named, how many Telgis are places? Because Telgi is a village in not only in Karnataka, also in Bihar. That's what I came to know. I used ChatGPT, I used AI Bing, I used Google search. Google search initially said, no, I cannot do all these things, and I had to train it. Ultimately, it agreed, and it started listing. And it went to the head notes, and I said, make me a table of these case number, when the case decided, who were the associates which were along with Telgi associated in the case. That's all. It said first 2 months time it will take. I coaxed it. I trained it about 50 cases. I said, this is the way you have to do. Then it gave me 3 days time to give the reply. It has not yet come. My request is, in the text search column, you just have to add AI engine like Google Bard or something, and we can ask better questions and get better answers from there. This can be done in 2023 itself. Kindly get it done. As far as you, Professor, 2024, you got a good chapter on tax. I have worked on 4 taxes directed at source when I was dealing with the CWG case. I have done a study report on property tax here in Bangalore. It's a compendium available on the net. Property tax collection is less than 5,000 crores in Bangalore, and we can collect up to 40,000 crores. There is so much of potential. Just before COVID, you complimented COVID. COVID came in the way of my implementing it in Delhi. That commissioner is still there. He wanted me to implement it. He had only 5 lakh people in the database for paying property tax, whereas the electrical connection said 17 lakhs. And when 30 lakhs are there in properties in Bangalore, Delhi must be having at least 40 lakhs. The collection is only, target is 1,200 crores per annum, where it has to be several crores. So we gave a solution. Unfortunately, after presentation, everything, COVID came in, lockdown, nothing happened after that. The person is still there. You can take the solution. You have to make a little more platform building and things like that. Please understand, there is a judicial function done by the commissioner. He discusses, he is the only person to do what is the tax assessment, and there are a lot of grievances on that. Bangalore has more than 1 lakh tax assessment grievances pending. They all land up in the High Court and the Supreme Court, etc., goes on. So in 2024, you can solve the problem of doubling of the tax revenues in Delhi or in Bangalore or 10,000 ULBs in the country, in any ULB you want to take up. Take it, solution is there, I'll give it to you. Please get it implemented so that you have a use case of increasing the tax collection, doubling it in 1 year, so that money is available for bringing about reforms. Right up to. Thank you.
Thank you.
As regards the first one, sir, that probably we look at it. The second aspect that you did put across to Professor Dolia, you'll be happy to know that now the BBMP is mapping all the properties, mapping the properties to the BESCOM, BWSSB. Now the problem with Bangalore was that we had so many numbers, Kaneshwari number, house list number, municipal number, Kata number, PID number, etc. Now there's a uniform number which is coming, which is also being mapped. So all those things there probably can be done is what I would say. I'm monitoring one. Let me put that in place.
Please, next. Yeah.
Hello, hi. I have a fairly simple question, and it's slightly more open-ended. But so you alluded to how these technologies don't seek to replace any functions, but rather help in tech-aided sort of decision-making, and then with AI and data mining, as some of the chapters are relating to. Just want to understand from everyone's perspective, what are those answers that we will get from looking at data at the scale of Indian judicial data, and what are the questions that are most pertinent to ask of that data? Would be great to hear everyone's perspective on that.
Yeah, so some of that I talked about when I just said how data, can be used for various judicial functions. For example, what is the right way to schedule cases, right? What's the best way to calendar cases? That's one possibility when you use data. From a user, from a citizen point of view, for instance, one of the projects that we have in our COE is, you put the facts of the case into the system and looking at the past data. And all AI methods, therefore, are less than human intelligence because they're only retrospective, right? They can't produce anything new. It's all based on analysis of the past data. So based on the past data, two things. What is the likelihood? One can't say for sure at all, right? In any case, what is the likelihood of if I'm the person searching for that information, actually winning the case? And two, what is the likely duration of that case? So such things can be done, and like that, there can be many other use cases that one can come up with. Right? I mean, we can probably do a separate session. Yeah,
It's a big open-ended question, lots of points. So I think with that we will wrap up the discussion. You had one question, yeah. Sir. The lady in the front, please. Yeah, the last question actually. We're getting close actually.
Hi, I'm Tej, and I'm from Information Design discipline from NID. So my question comes from a perspective of design. Here, my understanding is that technology is just a tool and it's an answer. And most of the questions need to be asked, and somebody is sitting behind and then deciding what the decision should be done, like by the customer. And even when we take the data, like he mentioned, these decisions can be probably you can say that they are 90% true, could be true, right? Why is design not part of this discourse? And why? And what kind of, do you have any scope for design and designers to be part of this book? Because I think the questions come from there, and that's it. Thank you.
Design is going to be the fundamental base for everything. UI, UX, what I spoke of some time back, is design. Even that cause list, the design of the cause list is to be such a way that it should be easily understandable by anybody. So design is not colors, or it is not font or anything. The design is the design of the presentation itself. So if you are going to make a software for paperless software, what is the design? How is it convenient? How can I use it easily? How intuitive it is? What is the user interface and what is the user experience? Simple, UI, UX. UI and UX of an Android and UI, UX of a Apple, there's difference, but they are good. That is why you are using it. There's some other software which came in which did not do well. They did not become good smartphones. So UI and UX as design, I think it is very much important to have design persons who can be part of each and every aspect of it in terms of the software, anything that you do.
Yeah, no, just to add to both the data question as well as the design question, I absolutely echo Sir's point. I think design is critical to framing, both in terms of how does the technology, how do you interact, as well as the entire system from beginning. So how does a litigant or somebody who is approaching the court, and of course the imagination is of an individual litigant, not a corporation, etc. But how does this person navigate the court system? In what ways are some aspects of the system designed to exclude, and how can we find ways to ensure that the only thought on design though, and I don't know if design researchers will agree with me, some of the thrust of design work has been oriented towards lessening friction and increasing consumption. So it is oriented towards making a choice. Whereas here it may not need, it might need an orientation that's very specific to how the judiciary functions. So that's a very brief intervention on design. I think on the data point, I think, Professor Bolia said it, but for me, there are two, so there's a resource allocation problem to my mind in the judiciary. So how do you allocate efforts to different aspects of, whether it's in the cause list making or, how do you allocate cases to a group of judges? And the second aspect, I think, is also the insight that you can draw from previous decisions to have some prediction of what the future is. So data can play a role in solving the resource allocation problem more immediately and very directly in my mind. The insight question, I think, is a little bit more of an unexplored territory and one that has to be explored a little bit.
Just to add, in fact, we are speaking of this yesterday, design. There's Stanford, there's a book, Law by Design by a Stanford professor. It speaks of all the things that can be used as a design element for law. And there is a legal design lab at Stanford. So you could look at that. I think all of you also could look at it because it is design. Design, according to me, is fundamental.
In fact, one of the first papers that we pushed out from the center was on UI UX of High Court websites. It's a very preliminary effort, but I think it kind of set our thinking and said, this is really important. Whatever else you do next, you have to approach it from this perspective. So with that, we wrap up the panel discussion. I hand it over back to my colleague Sandhya.
First of all, thank you to all our panelists, because I think some of the points that I'm not going to take too much of your time before I give my vote of thanks. I think there's a lot here that resonates with us in so many ways, because fundamentally from the first question where we set the tone for the discussion in terms of how are we going to think about deployment of technology in the justice system, which is fundamentally a public institution and we associate it as a public function, and where do we delineate the services part of it, and how we try to still make use of technology so that wherever that application is plausible, we don't let go of that opportunity. I think that's something that's going to always keep coming back in different ways, because that's the nature of our system as well, because sometimes the process and the administrative tasks are also intertwined with the substantive tasks as well. So I think that question will be fundamental in all our research and everything that we approach. I also think it'll be a bit amiss if I don't say anything about data, because I've been conditioned properly at Daksh to say a few words about data, because we've had Professor Bolia make a very important point, actually, because when you do have the data and you have that nuance with data as well, you do understand whether the delay is a doctrinal issue that's coming from law, because that gives us an indication that we have to revisit some of our provisions and change the law there, because it also sort of ties in with some of the things that Justice Suraj Govindaraj was also making about how so many cases are pending in compliance, sometimes cases are pending in process fee. So it also ties in, the data helps us understand where the delay is happening, why it's happening as well, because when it comes to process fee, I think sometimes, I can speak a little bit for the fraternity as well as a lawyer who's now a researcher. We also have this behavioral change issue as well, because that also ties in with technology. So I think the panel discussion was interesting. It gives us a lot to think about, and I thank the audience for raising some important questions as well. With that, I'll proceed with my vote of thanks. First and foremost, we would like to thank all the authors and contributors, and a round of applause, yes. A note of thanks is also due to the team at COE, which consists of Deepak Gautam, Soham Ghosh, Mansi Gupta, Surabhi Bhatia, and Krishna Shah. We are also thankful to Aditi and our editing team, and Mr. Bhupendra Yadav and the Oak Bridge team for helping us with this volume. We are also thankful to the Infosys Foundation for their support. A special thanks to, of course, our panelists who've given us our time and a lot to think about as well. And BIC, it's always a pleasure to have our events at BIC, so big thanks to BIC for helping us host our event here. And finally, thank you everyone for joining us and making time on a Monday evening. It's really appreciated. With that, I think I'll wrap up. If I could just request the panelists to take a photo with a copy of the book, and I could also invite the authors who are present here to join